Hello, everybody. Thank you for joining us today at this Your Overseas Home webinar. My name is Hannah Armstrong and I'm going to be hosting today's session. First off, I'd just like to apologise that my camera doesn't seem to be working today due to technical issues, but crucially, you can see our speakers, which is the most important thing. Now, today we're going to be discussing how you could claim back a missold mortgage. It's wonderful to have you all with us listening in today, whether you're with us live this evening or you're catching up with us on demand. We're delighted to be able to support you in your property buying journey and help you with this interesting issue of Spanish mortgage claims. Today's session will be a maximum of 30 minutes long, and for those of you who are listening in live, there will be plenty of opportunity to put your questions to today's panelist. So do pop those questions in using the questions tab and we will get as many of those answered for you. So it gives me great pleasure to welcome our panelists today. We have Javier and Jose Luis and Emma from JLCA and AS Lawyers. Now, we've been working with this company for a number of years now. They're a fantastic team, really well placed to help and support you with all of your property needs. If you do need a reminder of anything that we're going to discuss today, or you want to share this session with family or friends, a replay will also be available on the Your Overseas Home website. So just to give a little bit of intro to our speakers, as I mentioned, we have Javier with us today, who is a Spanish national, but he lives now in the UK. He's fluent in many languages and has a number of years' experience in managing and overseeing the day-to-day operations of the firm. We also have Jose Luis, who's a senior partner and actually one of the original founders of the business that started 24 years ago. And his aim was really to set up a multicultural team to help assist foreigners and Spanish residents to protect their rights and their purchases in Spain. And sitting alongside Jose Luis today, we also have Emma, who's a paralegal within the team, who has first-hand experience as life as an expat living over in Spain. So really well placed with that personal experience of her time moving over. So enough from me, and I will hand over now to our speakers. And I don't know who wants to take this first question, but I would love it if you would just give us a little bit of background into the firm and how you do support your clients. I think is someone on mute if you're going
There
for
we
it.
go. Yep.
Thank you.
Can you hear me now? Okay, very good. Thank you very much for the introduction, Hannah. And hello, and thank you everyone for being with us this evening. GLCA Lawyers, a brief background on the firm. We are a private law firm dealing with private clients, mainly with the expat market. So anybody who's got interests in Spain. We deal with many British clients as well as sort of European-wide clients. We have a heavy accent on property matters, so we do a lot of real estate, whether it's real estate disputes, property buying, selling, even managing and helping clients settle in Spain. We do a lot with immigration, family law, and pretty much looking after individuals' private affairs. However, today's topic, as we do quite a bit of litigation, today's topic is on mortgage claims, and specifically claims related to floor clauses in Spain, which some of you may have heard of. But for those who haven't, I will briefly explain what that is. A floor clause, which is referred to in the UK as a collared mortgage, is whereby a floor or a collar is placed on the interest rate that you would pay should you take out a mortgage. So you could take out a floating variable interest rate. And what this collar or floor would do is say, well, you will never pay less than X. Now, this floor typically inserted also anything between 3.5% and 4%. Now, of course, it went largely unnoticed during the noughties when interest rates were 5-6%. But then came along the financial crunch in 07, 08, and interest rates started plummeting. When interest rates plummeted, people expected their monthly payments to go down. But of course, they didn't. Nobody knew about this floor clause. Why not? Because it was inserted and hidden away in page 33 or something of your mortgage deed. It was never explained in full to anybody. So it came as a large shock to most people. who couldn't take advantage of the Euribor, as it was in Spain, going all the way down to zero. So if you had, for example, a floating rate of Euribor +1, and you had a floor clause of 4%, instead of paying your 1% or 1.5% that you could have been paying, instead you were still continuing to pay 4%. Of course, it annoyed everybody. And this has now become in Spain pretty much like PPI has here in the UK, a mass claim market. Everybody's claiming successfully. Special courts have been set up to deal with the volume, and it's a relatively straightforward claim for us to make. For you to understand more about the legal basis behind this, I'm going to pass you over to Jose Luis, who's a senior partner of the firm, who will be able to tell you more about how it came about.
Okay, thank you very much, Javier, and many thanks everybody for joining us this evening. And though my English is not as good as Javier's and Emma, I hope you can understand me. Okay, so what happened in this situation? Why we can claim? It was the Spanish Supreme Court that declared in its judgment in 9th May 2013 that this clause was abusive for not having informed the consumer, declaring its nullity and elimination from the contract, with the effect of restitution of the unduly paid amounts from the date of the judgment, which was in May 2013. Later, after the controversy with the banks and consumers, and above all knowing what could be claimed, the judges in Spain brought the matter to the European Court of Justice, based in Luxembourg. And in the judgment dated 21st December 2016, it declared that the consequences of this annulment meant the full restitution to the consumer of all the amounts overpaid from the start of the loan, as well as the respective interest, which meant being able to claim a very significant amount in each single case. It should be noted that on behalf of Spain, for consumers, four lawyers were chosen by the Spanish judges with respect to their experience and the volume of these cases, who then went to Luxembourg to defend the interests of consumers. Amongst them, and we are proud to say that a member of our law firm, JLC Lawyers, was chosen. This lawyer is Francisco Garcia, who since then, and working all together with our firm, has been defending consumer rights in hundreds of cases with a 95% success rate. So, who can claim? That's a good question. So, anyone who requests the mortgage loan for the acquisition of home improvement or of their own residence. That is, any borrower who has the status of consumer. For example, a Spanish property purchased by a British person as holiday home or to let, but excluding those who bought to investment, for rental, etc. Just to clarify, consumers consider are individuals, not companies. Another important point, is there any deadline to claim? No. We are talking about a declaration of abuse that entitles a radical nullity, which means that the action to claim can be done at any time, is not involved. So allow me just to pass to you, Emma. She will be following with this presentation.
Good afternoon. Basically, what I'd like to follow on with is the actual process of starting to look at whether you can make a claim and the documents that you actually need to do for this. It's relatively simple because the basis of these claims is a copy of the mortgage deed itself and details about the payments. Ideally, a amortization table of the installments paid from the beginning. What this means in reality is copies of your mortgage statements, receipts of payments, installments for your mortgage. And then we can pull this information together, which will be analysed and reviewed by an expert economist, accountant that we work with in order to provide the information in a way that is suitable then to submit for the claim. Now, a lot of people will already have this sort of information to hand or be able to get hold of it. For example, when they use the Spanish lawyers in the first place purchasing the property, they may well be able to get the information for them. But this being said, if you still don't have this to hand, we can get this documentation for you on your behalf. we can do this with your authorization with a power of attorney, which allows us then to deal with the banks and entities on your behalf to gain the same information that we need. It's a process that we do all of the time, not only in other claim types, but also with extrajudicial work. So it's a very simple process for us to go through in order to make sure you've got what you need to make a claim. The process itself will start extrajudicially. This is where it always begins. And then if the financial entity rejects the claim, which does happen the majority of the time, banks are going to look for any opportunity they can have not to pay. So it then proceeds through a specialist set of courts that deal with this specific type of case. In respect of which years are actually covered and have a possibility of a claim, although from 2013, 2016, with reference to the judgments that Jose Luis mentioned, the majority of banks stopped using the floor clause, obviously because of the results of the judgments and the claims against them. We can't actually rule out afterwards. There are still some banks that continued to use the clause after this point. So from our point of view, anybody that has had a mortgage that could possibly be subject to this claim, even if it's a few years afterwards, we would suggest it's well worth sending us copies of the documentation for us to review to see if there is an option or not. I'll pass you back to Javier because he will then be able to give you some ideas about the specifics of the claim amounts that you can actually achieve.
Very good. Thank you. Thank you for that, Emma. So just very briefly, and just to finish off, a little bit on the qualifying criteria to make a claim. Essentially, any mortgage taken out after 2000 is likely to have had this clause inserted into it. And of course, as I said before, it only sort of became it only applied for when interest rates went down in 2009. So you would have had to keep made mortgage payments from 09 through to about 16 when these clauses started getting removed from mortgage contracts. So just to very quickly quantify it, and it will depend on the terms of the mortgage, the term, the length of the mortgage, what the interest was monthly, 6 monthly, annually, or daily interest rates calculated. But if I give a sort of a broad term example of a 150,000 mortgage taken over a 20-year period, if your floor clause in your deed was 3.5%, the amount of money you would have overpaid in the period from 09 through to 16 would have been about just over 12,000 euros. Add legal interest to that, and you're looking at a claim of about 15,000 euros. If your floor clause was 4%, which is the more abundant one, the overpayments you would have made during that same period for that same mortgage, 150 over 20 years, would have been 17,000 euros. Add legal interest to your claim, and you're looking at a total claim of about 20,000 euros. We don't have anything further to add. So what we'd like to do is maybe go back to the floor for any questions that you may have for us.
Thank you. That was a really wonderful introduction and very helpful. And I just wanted to double check on one of the points on behalf of one of our viewers today, Stephen. Stephen has asked to just clarify, he has paid off the mortgage. He's cleared it completely now on the property. Is he still able to claim in that case?
Absolutely. Yep.
Brilliant.
As long as, yeah, it doesn't matter whether you've paid it off or not, or when you've paid it off. It's if you've made payments during that period, then you certainly claim.
Brilliant. And can you tell us how long typically the claim process might actually take, from initial conversation with you to kind of this going through the process?
Yeah, I'll let Jose Luis elaborate on that, but because of this special course being set up, and the nature of the claim, which are being sort of settled within, that don't even end up in trial. So we're looking at about 6 months, I believe. Is that right, Jose Luis?
Yeah, well, the thing is, they are special courts, as you said, and then they are very, very busy with all these cases. However, the good news is that in 90% of the cases, they go from the pre-hearing to the judgment. So we don't have what is called the hearing. So in a year time, we understand that we can have the resolution of the case. We can have the judgment, and we must bear in mind that the banks, they are quite solvent, and also we work in a win-win basis. So it's just a matter of time for you, if you're interested, to go ahead with this.
Thank you. That's very helpful. I hope that has answered those queries for those listeners. Now, I wanted to understand if you've actually sold the property that was affected. So you took out one of these mortgages, and then you've now, in the past couple of years, sold that property, but you obviously still, made these payments when you were paying that mortgage. What would happen in that instance? Could you still have a claim then?
Absolutely, yep. Similar to if you've paid off your mortgage, which would have you sold your property as well. Same scenario, you can still make a claim as long as you've made payments.
Brilliant.
Whether you hold the mortgage or not, yeah. Absolutely, yeah.
That's very helpful. Now we've got a very specific question, which I'm going to read out word for word, just to make sure that I get this correct on behalf of the customer. So Graham has asked, the mortgage was taken out in 2012. Floor clause is 4.5% and still paying that rate. Will the rate reduce as a result of the claim?
Absolutely, and that's the double edge of the claim. Not only will you recover all overpayments made, but for those, in Graham's case in particular, that clause has not been removed yet, which is pretty bad, and only enhances the level claim. You'll have a pretty good claim, I would say. The other result of making this claim is that we will have that. I mean, essentially, the claim is to have that clause declared null and void. Removed, it never existed in the first place. The compensation element is a byproduct of the fact that that clause should never exist in the first place.
Brilliant. That's very helpful, and I hope that answers that question. Now, another question, I believe that's a common one that you do get. My bank was Bankia, and it's now, I'm saying this terribly, my pronunciation, it's now CaixaBank. Thank you. As a result of the merger. So how does those banks sort of merging impact for any customers that are affected?
It doesn't. The liability is taken over by the acquiring bank. And this has happened especially with all the little cajas, as we call them in Spain, which are like building societies in the UK. All the little sort of banks and building societies that sort of went bust in 08, 09 and got absorbed, taken over by the bigger banks. With that comes not just the profit, but also the liabilities.
Thank you. That's very helpful. And I wanted to ask if there, it sounds like this is a quite all-encompassing opportunity for people to claim. It sounds like most circumstances would be taken into consideration, property sold or anything like that. But are there any sort of common exemptions to people making claims? Any circumstances that customers do need to be aware of?
Yes, there are. Jose Luis mentioned earlier, you do have to be regarded as a consumer and have consumer rights. That negates any commercial venture having the possibility to claim. So in other words, if you happen to buy a property through a limited company instead of in your own name, you can't have a claim. If the bank deems that you bought that property purely as an investment to let out and you're renting it out and exploiting it, again, that takes away your sort of consumer rights, so to speak, because you're now a business. So unless it's either your residence or second residence, in other words, holiday home, you can't make a claim.
Thank you. That's very helpful. And just to expand on that point about holiday homes, so say you used it as a holiday home, but you also rented it out to other tourists and holiday makers, but you also did use it yourself. It wasn't solely a sort of business venture. How would that impact the possibility to claim?
It wouldn't. It is your, even if you spend one, even if it's empty, as long as you're not letting it out, it can't be portrayed as a business venture. It's your second home. So
as long as the bank is not able to prove that you have used that unity as a business, but that's our task. And So if you have rented to friends or whatever, you can claim because it's very difficult for the banks to prove it. But if you are renting in permanent basis, I mean, if the bank knows it, it will be quite difficult to defend that case. But I mean, we have to study every single case, and there's always a loophole to get through.
Thank you, of course. And I think that's really important at this point to stress that everybody's circumstances are different. So we strongly recommend that you get in touch with the team at JLCA as quick as possible, because they will be able to help with your personal circumstances, and they will be able to explain, you know, in particular detail that we're not able to cover in this session today. And on that note, I think it's important to ask for our customers, and I know this question is always, you know, how long is a piece of string? But can you give any indication about how your fees would be calculated for a claim like this, or perhaps what costs a customer could expect to incur if they were to make a claim like this?
We were able to offer a no-win, no-fee solution to our clients. In other words, it wouldn't cost them anything upfront. Apart as being in Spain, they would have to give us a limited power of attorney, so there would be a small notary fee of circa 150, 200 pounds. That would be the only upfront cost. With that, we can represent them in court, and we charge a 30% fee, but only on any awards recovered on behalf of the client.
That's brilliant. Thank you for clarifying that. And actually, on that point about power of attorney, it's important to just ask, because particularly in the case of customers who it is a holiday property, are they able to do all of this whilst they're based here in the UK or their other country of residence? They don't have to be in Spain for this process to be taking place?
Absolutely. We arrange powers of attorney through notaries in the UK all every day. There's actually a huge number of notary publics that work in the UK. So our task normally is to find the one that's closest to the client to minimise the inconvenience to them in signing it, and we make all the arrangements for them there and the documents that they need in order to get it signed.
Brilliant. That's very helpful. Thank you, Emma. I think that's the last of the audience questions that have come through today. And we've got a couple of minutes left before we do need to wind up. So just if there's any final points from the three of you that are sort of key things that you want to make sure that that you get across to the customers. As I said, my key point for you all is definitely do get in touch with the team at JLCA as soon as you can. But any final points that you want to make our listeners aware of today?
Yeah, just to build on the importance of getting in touch with us, there are a number of other possible claims that can be found within. So obviously we're talking today specifically about mortgage claims in terms of floor clauses, but there were quite a few other sort of, let's call it, dirty tricks that mortgage lenders in Spain did use. And by just looking at your mortgage deed, we might be able to identify a number of claims. Even if it's not a floor clause, we might be able to identify some hidden commissions or overpaid fees, a number of other sort of naughty things banks did, which we are experts in claiming against. So certainly recommend us having a look at your mortgage.
Yeah, allow me to add something else. So basically, the banks, they got your money. You don't deserve it. So it's time to recover it. Okay, so let's go for it. We can make it, and don't be shy. I mean, I'm sure we can recover the best compensation for you. So let's keep in touch. Thank you very much.
The thing is as well, as Jose says, this is an opportunity for people. The way that we work is that we review the documentation, we find out if you've got a potential claim, and we look at all the possible options for you. And this review of your documents is free of charge and without obligation. So you really don't lose anything in having a look to see what we can do for you. At the end of the day, if we present the options and you're not interested, then we leave it there. And if there are options that you pursue, then hopefully you'll go away a little bit better off.
That's brilliant. Thank you very much. And I promised to sneak in one last question that has just come in from the audience. Those sort of dirty tricks and things that you mentioned there, are there, do you have any recommendations of banks that you would perhaps suggest customers avoided? And you know, on the other hand, any banks that you strongly recommend working with if people are actually, you know, about to start a property purchase now, anybody that they should avoid or anybody that they should go to?
That's a very tough, it's a hard question, because we cannot say don't go with this bank. We can just go against the ones that didn't do the things properly, if you follow what I'm saying. So I can't say anything wrong against a bank now in order to avoid any coverage with this bank or the other bank. But once again, if this client wants to have our opinion, I mean, he can contact us privately.
Of course. Thank you very much. That's really helpful. And I think that's about all we've got time for. So thank you, Emma. Thank you, Jose Luis. Thank you, Javier. It was really wonderful advice that you've shared with the listeners today. So I hope that's been useful. As I mentioned at the beginning, and as I'm sure you're aware, at Your Overseas Home, we have a huge number of different resources available on our website. So we'll pop a link up there now. We've done several other events with the team at JLTA. So there's loads of wonderful webinar recordings that you can take a look at there. We've got our buying guides. We've got lots of different upcoming events happening in the future, including a full day virtual event with the opportunity to talk one-to-one directly with various partners, including the team you've met today. So loads of opportunities there, loads of resources to help support you with property purchase. If you've already purchased, but you know, you need relocation advice, these mortgage claims, anything like that. So do have a look at the website and we'd be delighted to help you with anything. Thanks again to our speakers, and thank you to everybody who's listening in, whether you're live or catching up on demand. It's a pleasure to have you with us, and we wish you all the best. Many thanks. Bye.
Thank you very much.